Good afternoon. Welcome to the DOJ Civil Cyber Fraud Initiative and Beyond, Considerations and Recommendations for In-House Counsel. We're so glad to have you join us today. I know it's going to be a fantastic program. We've got a magnificent panel assembled here today. We've got Kelly Greening, who will be our moderator, Shobha Pillai, Greg Pearson, and Raj Laud. We will be introducing the panelists very shortly. In the meantime, I'm Janelle Carter-Anderson, and I am both a board member of the Chicago Chapter of the Federal Bar Association and chair of the Corporate and Association Counsel Committee. If you are not currently a member of the Federal Bar Association, I encourage you to join. We have a very robust schedule of events that we host throughout the year, including free events and webinars for in-house counsel, and other practitioners in the federal bar and in the Chicago area. So we do encourage you to join. There's a link that can be found on our website, fedbarchicago.org, which can provide you with more information regarding membership. At this time, I'd like to introduce our moderator, Kelly Greening. Kelly is Associate General Counsel at Anne and Robert H. Lurie Children's Hospital of Chicago, where she advises on privacy, security, and other regulatory matters. She previously served as Deputy Chief of Financial Crimes and Healthcare Fraud Coordinator at the U.S. Attorney's Office for the Northern District of Illinois. She clerked in the Staff Attorney's Office for the U.S. Court of Appeals for the Seventh Circuit. Before I turn it over to Kelly, though, I just want to remind you of a couple of housekeeping matters. You can download handouts for the discussion in the control panel section. You can also download the CLE form there as well. Please be sure to do so before the program ends, because after the program, you will not have access to those forms. If you would like CLE credit for today's program, please complete and return the CLE form to info@fedbarchicago.com. There will be a code that will be mentioned at some point during the program. It will also be entered in the chat, and then it will be mentioned again at the end of the program. So pay attention at one of those times. Be sure to jot down that code so that you can include that on your form for CLE. But I'm looking forward to the discussion today. I know it's going to be practical and informative. And with that, I will turn it over to Kelly Greening, our moderator.
Thank you, Janelle. Thanks everyone for joining us today. We're thrilled to have this wonderful panel for you and what will be a robust and interesting discussion. So I will introduce our wonderful panelists. First, we have Raj Laud. Raj is the head of cybersecurity and online safety legal at GitHub Inc. He previously served as deputy chief of the National Security and Cybercrime section of the U.S. Attorney's Office for the Northern District of Illinois. And he also clerked for the Honorable Joel M. Flaum of the Seventh Circuit Court of Appeals. Next, we have Greg Pearson, a senior trial attorney at DOJ and Commercial Litigation Branch Fraud Section, where he's worked for over 20 years. He primarily handles False Claims Act cases, including investigations and litigation. And he has a nationwide practice that covers matters involving many federal agencies, including the Department of Defense, Department of the Interior, and General Services Administration. And finally, we have Shobha Pillai, who's partner and co-chair of data privacy and cybersecurity practice at Jenner & Block. She's a corporate crisis manager with extensive trial and investigations experience, who leads complex and high-stakes internal and government-facing investigations and advises clients on cybersecurity threats and national security risks, and developing robust regulatory compliance programs. She's also a former federal prosecutor at the U.S. Attorney's Office in the Northern District of Illinois and has significant experience in complex investigations and prosecutions involving cybercrime and other areas. So welcome to our wonderful panelists. Thank you all so much for being here. And Greg, I would like to start with you. Can you provide an overview, please, of the DOJ Civil Cyber Fraud Initiative and its goals?
Sure, thanks, Kelly. Before I get started, I should probably just make clear that I'm speaking on my own behalf today and not on behalf of the federal government. So nothing I say should be interpreted as the position of the Department, Justice Department, or the federal government. At any rate, yeah, the initiative is really part of a larger effort by the nation as a whole to address cybersecurity. The challenges the U.S. is facing, not only publicly, but also in the private sector. In May of 2021, almost 2 years ago now, the president issued an executive order laying out broadly what the United States is going to do to address these challenges. And in line with that, DOJ has had a renewed focus on cybersecurity in the last 2 years. The criminal division is doing its part, the national security division is doing its part, and in the civil division, we've got this civil cyber fraud initiative, which really boils down to using something called the False Claims Act to help enforce cybersecurity clauses in federal contracts, cybersecurity regulations that govern contractors, or really anyone who's taking federal funds. Before I sort of get into a little bit more of how we see the initiative playing out, I was going to speak briefly about the FCA. I'm sure everyone here has probably heard of it. Everyone here has probably worked on cases involving the FCA. But just so we have some context, as you probably all know, it's the government's primary tool for addressing fraud against the federal government. It includes not only fraud, but also any false claim for money or property where the other elements of the statute are met. So that if you're claiming money you're not entitled to and you're doing it knowingly and the falsity is material, you violated the False Claims Act. And that's sort of the same way we approach it the same way in every case, and we're going to do so, and we have been doing so in the cybersecurity arena. I thought it would be helpful to go over sort of 3 or 4 areas where we think the FCA is going to be implicated here. This is not an exhaustive list, but it should give us some context to sort of think about this, not only today, but just generally. The first area is where the government owns the network at issue. As you probably know, every federal agency has a computer network. Some have many computer networks, different enclaves. And often the government will use contractors or other recipients of federal funds to develop the network, maintain the network, improve the network, do all sorts of things with the network, right? So those contracts, and sometimes it's not the contract, sometimes it's a regulation, will often have cybersecurity requirements. If those are not followed, that could implicate the FCA. Another area is a situation where contractors own the network, so to speak, but the government is housing either federal information on that system or perhaps patient records or something else the government wants to keep secure. Often those contracts will include cybersecurity requirements. If those are violated, that could implicate the False Claims Act. Another area is the cloud. As you know, lots of services and apps now are run in the cloud. The government does that and is doing it more and more every day. We generally use something called FedRAMP to implement cloud cybersecurity regulations. That's done through GSA. And the final area is supply chain. The regulations and contract terms that govern this area are sort of developing as we speak, but that's going to be a big area as well, I think, that making sure that the security of software and hardware is not compromised as it comes to market. So that's just sort of to give everyone a flavor for sort of where we think this is headed, essentially using the False Claims Act to really go after these areas more than we have in the past.
Thank you, Greg. Shobha, I'll turn it over to you. So many of your clients, I'm sure, are going to be concerned about what type of risk they would face in in-house counsel, especially. So what types of penalties or fines can companies face under the False Claims Act? What's the risk here?
Sure. Yeah, it's pretty robust. The baseline fines per violation used to be $5 to $10 grand, but last year DOJ announced that, like everything, fines are also impacted by inflation. So it's up to $12,500 to $25K approximately for the actual fines per violation. But the more important number to be thinking about is that the government can seek damages at twice the amount of loss experienced by the false claim. So in other words, if a company is held liable for one false claim on $1 million contract and that whole $1 million is at issue, so they receive that money without in a material way for which they were not permitted because they made a false claim, the ultimate penalty for that one lie could be up to $2 million plus another 12.5 to 25,000 for that one violation. And think about how that aggregates depending on how many false claims, because it's, contracts are really complicated and robust. There are a lot of regulations with the federal acquisition regulations. So I think it could be quite catastrophic, as you'll see. I think it's important to note also that in 2022 alone, the DOJ collected upwards of a little over $2.2 billion in penalties for False Claims Act violations. More than close to, I think, $1.7 billion involved the healthcare industry. So that's an area that's enforced quite robustly. And I think in the cyber context, you're going to be seeing this a lot in the context of PHI. And there's a lot of risk to a company to think about, not just the financial harm, because obviously you have just a significant loss to the company by virtue of having to pay a fine or penalty. But you also could, there's reputational harm. If you're a public company and now it's disclosed that you failed to secure this data or you failed to comply with certain cybersecurity requirements, you could have an impact on your stock price. You could be subject to other private litigation involving the loss of that data, loss of security on that data, could be a shareholder derivative action, all the sort of additional risks that go with all cyber related issues start to rack up. And then there's a range of regulatory harms that we're going to talk about later that could increase your liabilities just beyond the FBA.
Thank you. Greg, back to you just to follow through on this thread about the False Claims Act. So the False Claims Act has a unique feature under which private individuals, qui tam whistleblowers, can bring cases on the government's behalf. So in your experience, is the relator bar aware of this civil cyber fraud initiative? Are you seeing qui tams now in the cybersecurity space?
Oh yeah, the qui tam bar is very aware of the initiative. Since we announced the initiative, we've seen an uptick in qui tams filed involving cybersecurity. We spoke in addition to this event, we spoke at numerous other events, including events that are just for the relators bar. And they're very active in this area. And they were active in this area actually before the cyber initiative was announced. In fact, there was a case filed, I think it was 5 or 6, maybe 7 years ago now, in the Eastern District of California against a rocket manufacturer by a qui tam relator. It's called Aerojet. You all may have heard about this. We declined, but the United States declined to intervene in the matter. But the relator pursued it through discovery all the way to trial. And while the relator was actually testifying, the case settled. It settled for $9 million, which is a pretty good recovery for that particular case. And the relator bar is very aware of that result. And we've actually had another case recently that settled, I think it's about a year ago now, that settled involving healthcare information and cybersecurity that was also a qui tam action. So there's been success in the area by relators, and we've been talking it up amongst the relator bar, so they are aware of it, yes. But we also get cases not only from the relator bar, of course, but from our IG agents in the field. The IG agents are, we work a lot with the Inspector General community. Each federal agency has an Inspector General with agents, and cybersecurity is a big issue for them now. We've got a working group with many IG agents. We've been getting the word out to them, and they've been working with program people to sort of bring cases to our office, not only through hotline complaints, but also through just investigation and other tips they've received.
And Shobha, I'll go back to you. Raj, I'll get to you in a moment. What enforcement actions have you been seeing since the initiative, and what can companies like your clients take away from these examples?
Yeah, sure. And I think Greg actually identified the two public ones. So the Aerojet Rocketdyne is interesting that DOJ declined. That was an ongoing litigation with that relator and resulted in that $9 million settlement, which is public. But what's interesting is the relator, not uncommon for whistleblower, was an in-house cyber officer at the company, had concerns about the cybersecurity standards, would not sign the declarations to the federal government. And in this case, it was DOD, so they were subject to DFARS, the Defense Federal Acquisition Regulations, and NASA, so the NFARS regulations. and he didn't want to sign those declarations. He filed an internal complaint. He used their anonymous hotline. He did all the things I think you're supposed to do, or at least he's claimed to have done, to say, hey guys, we are not secure. I'm not comfortable making this disclosure to the government. And he was terminated. And as a result of that, he filed his whistleblower action. And this resulted almost going to, I think they were on day 2 of trial when they settled. And it really was, I think, reverberated throughout the community, both in any company, not just the defense contractor and federal contractor community, because it shows you the risks of recognizing that you have humans in your companies, and your humans might actually want to be compliant. So you have to be thinking about this more robustly. Think about all the way down to your line employees, the people that are actually securing your networks, what they know, what they understand, and what representations are to the federal government. Because then in March 2022, and that's the other one that Greg mentioned, it was the Comprehensive Health Care Services LLC was the company. They were providing services to and agreed to secure essentially medical data, patient medical data in Iraq and Afghanistan for the State Department and for the Air Force. And they didn't do it. They had some population of data that was on an unsecured network, which is inconsistent with the expectations, again, under the regulations. And so as a result, they had to pay $930,000 to resolve the matter with DOJ. And I think that, again, this identifies a critical point here. A, follow the regulations. You have to secure the data as you've said you're going to, and be honest about it. I think that's the part of False Claims Act is don't lie. And I'm going to say that probably a few times today. And it's a really hard thing because I think companies' expectations of how to stay secure is really hard, right? The threat landscape is really hard to manage. It's ever evolving. But the idea here is to be as nimble as possible and recognize there is a reasonableness standard. But in the FCA context, it's really about whether or not you are actually doing what you say you're doing, which is a little bit different than how secure you are. So I think we have to think about this through 2 buckets in the context of cybersecurity.
Thanks, Shobha. Raj, I'll turn to you. What role do in-house counsel like yourself play in preventing and addressing cybersecurity threats? And how, if at all, do you see that role as being impacted by this initiative?
Sure. So I'll start with preventing. And I think one of the things this initiative does is gives you something very concrete to point to when you're explaining to the rest of the business the risks here. And that is a huge role of in-house counsel, is to make sure your business understands that there are risks here. And I think it's really 2 prongs. One is you need to have a plan for how your product is being secured and how you're living up to the promises you're making the government. And there are a few different ways in which you could be interacting with the government that Greg covered. So it's going to be specific to the nature of your relationship with the government. But pretty much everybody's going to have an incident notification reporting requirement in their contract. So that's one that I think I'll focus on. So that also means you need to have an incident response plan in place before an incident happens. And your security team may have that, but you need to make sure that you understand what it is, that there's a role for in-house counsel in that plan, so that you'll be in the loop from the beginning if there is an incident. The next big category is in-house counsel is definitely going to be involved in a decision about whether or not to disclose an incident. And we're focused on the relationship with the federal government here, but it's really a broader question, right? Are you going to notify other affected users if there are other affected users? Are you going to make public statements about it? These are questions you want to think through, not for the first time during an incident. So again, what you can do now is come up with a plan. And then I would say big picture, both in the prevention and the response stage, your job as a lawyer is to ask questions. So that adds value. Don't be afraid to be the person who's there to ask the layperson questions. And just because the security and technology folks are going, 1,000 words per minute at very sophisticated terminology, it's okay to say you don't understand. It's okay to ask them to slow down and explain it in layman's terms, because when you're interacting with the government, or when this goes public and you're interacting with the public, then that level of understanding, the layperson's understanding, is going to be really important. So make sure you understand it. Great,
thank you. Greg, when When announcing the Civil Cyber Fraud Initiative, DOJ specifically noted that there was an intention to hold accountable entities or individuals that put U.S. information or systems at risk. Is it reasonable to expect that DOJ will bring cases against not only companies, but also against individuals involved in making these allegedly false statements related to cybersecurity?
Whether we investigate individuals or sue individuals, settle with individuals, that's really done on a case-by-case basis. I don't think it's going to be done here necessarily more than it is in other arenas. For example, billing fraud with DOD or Medicaid or Medicare fraud or fraud with the Postal Service or whatever agency you're dealing with or whatever realm you're dealing with. We generally interact with companies. We generally sue, settle, go to trial against companies. But we do from time to time go after individuals if they violated the False Claims Act. I think the announcement you're referring to probably just added the word individual in there because that's what we do. So, we sue both companies and individuals, but I don't think there's necessarily a special focus on individuals with respect to the this particular initiative.
Okay, thanks, Greg. But sticking on that individual thread for a moment, to Shobha's point earlier, should companies be paying attention to, for example, the high stakes for their CISOs and other C-suite personnel when addressing their cybersecurity risks in light of this risk?
Yeah, I mean, I think it's because you want the company to be secure, the people who own that responsibility, who are often people like a CISO or a CIO, and certainly the CEO and of course a board. The answer is yes, because I think owning that responsibility and recognizing the risk to that individual, while I understand Greg's point that they may not be at a higher risk than any other sort of defense or government contracting False Claims Act investigation, those False Claims Act investigations can also be referred to the criminal teams, right? So there could be, and they're more likely to pursue individual prosecutions in that context. And I go back to the catastrophic downside of these cyber attacks because they're so significant. The risks continue to be ongoing. It's because it's a risk to any company with data, and every company has data. Some companies will tell me, oh, don't worry, we just have customers who are other companies or vendors who are other companies. And then I ask, do you have employees? Yes, employees are humans and they have PII and they have PHI depending on the circumstances. And those are also at risk here. And so the expectation in the False Claims Act context is really about what data do you have that you're supposed to be secure and consistent with your government contract. But the criminal risks, which may or may not sort of stem from an FCA investigation, include, for example, what happened to the Uber CISO. I think it's really important to know all four of us are current or former federal prosecutors. This guy was a former federal prosecutor who was in a cyber crime role when he was at the U.S. Attorney's Office in the Northern District of California, among other things, and ultimately became a CISO at a huge company that had a lot of data. That company had already experienced a number of cyber incidents, and one of them resulted in the FTC engaging in a consent decree saying, hey, you guys need to have your data better. Greg, can we ask you to mute, please?
Sure.
Thank you. And as a result of that FTC consent decree, when Uber was the victim of another incident, the CISO made the decision not to tell anyone. We're going to pay the ransom. We're not going to tell anyone. But by not telling anyone and then affirmatively lying about it, both to his own outside counsel and the FTC, he violated the law. That was a crime. That was an obstructive crime. That was a false statement crime. And he was prosecuted and ultimately convicted after trial. And so that really, I think, from my experience in private practice, really impacted my clients, CISOs, and other leadership, because they are now wondering, okay, am I on the hook? And my answer is, well, if you lie to me, yes. So I think the answer is really, it's about being, again, it's about reasonableness, right? But being prepared for the impact to your company in the context of a cybersecurity incident. To Raj's point, have a plan. Don't be coming up with a plan in the middle of an incident. And don't lie. I feel like be prepared and don't lie are just kind of like common things that we teach our children. But I think it's really just, it is such a critical theme in this arena because it ultimately will protect the company from so many other regulatory risks in addition to the FCA.
And I think just to put a finer point on it, one of the takeaways that it sounds like both you and Raj would agree with is that in-house counsel should have a strong relationship with their CISO, and there should be open lines of communication, and in-house counsel should be understanding what it is that the CISO is working on. And a good CISO like mine will be able to explain in lay terms what it is that they're working on for someone like me who maybe doesn't have the same technical background as he does. Do you agree with that? The importance of a strong, either of you, you and Raj, if
100% agree with it. It's one of my preparedness guidelines when I'm working with clients in the initial preparedness analysis. If I'm doing a policy review, is I make sure any cyber in-house counsel or in-house counsel, even if they don't have cyber counsel, get to know, actually meets, which is a thing that's happened with me, meets their CISO, and let alone get to know them, have a regular ongoing relationship, an ongoing meeting, and get used to their communicating. Because this speaking CISO, this sort of translation problem as between the technical and the legal can be a challenge. And so once you start having those coffees and hanging out and getting to know each other and getting comfortable with each other, that communication starts to simplify, and everybody is starting to understand where the risks lie and what the lawyer's role in that context is and what the CISO's role in that context is. And I'll turn it to Raj, who actually I think deals with this on a daily basis.
Yeah, I mean, and I think that's probably a broader takeaway for in-house counsel is you just need to have a good relationship with the, individual humans that make up your client, right? Like technically you represent the company. Hopefully you're not too often in the position of having to remind your employees that you don't represent them individually. But, I mean, you have to have a relationship with the people who make up your client, and then you'll get accurate information. You'll know about things before it happens. So, I work for a company that's largely remote. So that means like one-on-one Zoom meetings just to catch up, on a bi-weekly basis, weekly basis, depending on role. If you're in person, grab coffee, grab lunch, just make sure you have those relationships in place. And that will definitely pay dividends. I totally agree.
Yeah, thank you. I agree with both of you. Raj, turning the page a little bit, Shobha had started to talk about criminal investigations. So in criminal investigations into cyber attackers, DOJ would often count on the cooperation of the companies who are the victims of those attacks. But here, those same companies might now be viewed as potential wrongdoers with civil liability. Do you see this as a major shift?
Yes and no. I mean, there's certainly a tension, but I think you got to think about the big picture here, and the old adage that the cover-up is worse than the crime. And in particular here, you've got a strong financial incentive for people within your company who know exactly what happened to come forward with that information if you attempt to cover something up. So yes, there's a tension and you want to be careful in how you navigate it, but it would be exactly the wrong lesson to draw from that. Like, let's not talk about these things, let's try and sweep them under the rug. So I think instead the takeaway is, to have a plan, practice it. You want to treat these situations with urgency so that if you do need to do a notification and you choose to do one, you're in a position to make it a timely notification. I work for a tech company, we're business to business. We have customers who are going through incidents all the time. So it's kind of routine for us. We get to practice our plan a lot. I mean, I think that's not the case for most companies. So I think practicing is important. You probably, I'll say this as in-house counsel, like I'm putting in a plug for outside counsel. You probably want to have an idea of who you'd go to for outside counsel if you needed advice. And just be ready to like gather the facts, understand the situation, be ready to make a call. And I think that also means not just the legal teams and the security teams, but your CEO should know about this, your board, and your PR folks, because it's different, I guess, in every industry. But I can't imagine very many situations where you're going to like notify government and not eventually need to make public statements about it. So you want to be ready for that too. We've touched on it a couple of times, but like the one, I think, game changer here is really thinking about key TAM liability, because my experience has been both when I was in government and in the private sector, if you cooperated with DOJ, you gave the FBI timely information, that got you a lot of goodwill, not just the criminal authorities, but with regulatory authorities who might be sniffing around the same space. I don't know that that's going to be exactly the same if you have well-funded, motivated plaintiffs bar who can take a case all the way to trial without the intervention of DOJ. So it's something to think about, but what's the alternative? You can't make the incident go away. You will not succeed, I don't believe, in sweeping it under the rug. So just be prepared to grapple with this issue head on.
Yeah, thank you. Shobha, do you have anything to add on how you might counsel clients on the approach about notifying DOJ of cyber attacks?
Sure. Yeah. I mean, and I think Raj touched on this. There is quite a coordinated plan. And so your incident response plan should have all of these pieces together, who your various vendors are, be it outside counsel, which you would want to hire first, and hire all your other vendors through them. So the investigation is covered by privilege to the extent possible. You would have your forensic vendor to the extent that that's necessary if you don't have sufficient in-house to do the forensics. And then, of course, strategic communications or PR firm if you don't have a sufficient in-house, which most companies do not. That all needs to be aligned early, because part of the sort of concept of the public statements, if you're gonna report to DOJ, is also, that's usually valuable if you have to report to a regulator, if you have to report to an individual victims, but knowing that your language is consistent. So if you're a public company, you have an obligation to inform your investors through typically an 8K, if it's off cadence from your normal quarterly updates, that this has happened, because it's a risk to the company. And potentially a risk to the owners of that data, who might be individuals, and of course maybe to the employees. So there is an expectation by the investor community, by the regulators, that you're telling people. So if you decide that you're going to make a disclosure, for example, in a criminal investigation to FBI, which I often would recommend early if you're going to do it, because you're going to get real-time threat intel about the threat actor. You want to know, okay, is this particular ransomware actor somebody who, if you pay them, they actually give you the key or delete the data, which you can't really verify. But there might also be some additional intel that you would like to know. For example, what if this is a sanctioned actor? You need to be able to do your KYC to make that determination, so you're not running afoul of the Department of Treasury and OFAC rules. So there's a lot of moving pieces here. And if you are a government contractor and you have a disclosure requirement almost certainly under those regulations, that discussion is part of that analysis. But one of the things you have to be able to do before you tell anyone is figure out what happened to the extent possible. So there's quite a lot of moving parts in what I just talked about, and all the different regulators that may have expectations of disclosure. So you would want your counsel to be prepared, and your incident response plan would articulate this. And to Raj's point about all the other people who need to know, the stakeholders in an incident response need to be identified as part of it, and their CERT team, the incident response team, typically involves your executive committee, so your CEO, your CFO, your COO, et cetera, because they're going to have responsibilities. If you have financial payouts, CFO should be responsible for that. And then, of course, your board disclosure. So there's all of that is something that I deal with on a regular basis, and the companies that are prepared are usually in a better position to be able to do this seamlessly. And preparing it, and what Raj's point about practicing, those are usually in the context of what we call tabletop exercises. So we give you a fact pattern, we walk through it, and you are responding to it in real time as if this were a real incident. It feels, I've had executives say, this feels kind of like a waste of my morning, until they realize how scary the incident could be, and now that they know who they're supposed to call and what they're supposed to do. So I can't recommend enough the concept of practice, and then understanding who your stakeholders are, and so they are fully informed.
Great, thank you. Really helpful, practical tips. It's past 12:30, so I'm going to give the CLE code. The code is 21194. I'll repeat that, 21194. Okay, so jumping off Shobha's very helpful entry into these really practical tips, my question for all of you is, what can companies and in-house counsel specifically do to mitigate their risks in this new environment? So Raj, I'll start with you.
Yeah, okay, so it's going to be a little bit like context dependent, right? The type of company you are, but I think, number one is, I'll just say it one more time, have written out a plan with your security team. Make sure you have a security team. IT is not security, right? Like somebody who's thinking about whether the services you're offering are secure and are provided in a secure way. Another big one I want to call out is vendors. So third-party risk, almost nobody does anything entirely in-house, particularly in the software world. Most things are built out of, either commercial software that's purchased and installed, or software as a service, is very common. Even like Microsoft Word, many people use in the cloud, right, as Office 365. So you need to understand who has your data, what their role is with it, and also who has access to your systems. I've seen, not to air GitHub's dirty laundry, but I've seen even at I think, fairly sophisticated tech company, we're much better about keeping track of the technology given out to our employees than we are to our contractors, which is really kind of on its head if you think about it, because the employees you have a very long-term relationship with, and the contractors come and go. So I really think thinking about those third parties, looking outside of just your own employees and your own companies, to who has access to your systems, who's involved in providing the services that you're providing, both in terms of people, software, hardware. If you live in that world, hardware has software, hardware has security vulnerabilities. That you want to take a deep dive into that. And a lot of companies have teams that really, they're not necessarily made up of lawyers, but they're made up of compliance professionals who dig in and really go through those risk, like a company-wide view of risk. Then the other thing I'll just say is, I would make sure you understand, if you have contracts with the federal government, what are the promises you're making? And if you provide software to the federal government, which is something that GitHub does, so it's on my mind, what is going into these submissions you're making to get and maintain certifications? Because the FedRAMP certification, I think, is a pretty juicy target for a False Claims Act submission. If you lied or misled or did something wrong in getting that certification that allows you to sell to the federal government, that seems like a pretty big risk to me. So I'll call that one out specifically. I'm sure others have thoughts on this as well.
Thanks, Raj. Greg, I'll turn to you.
Sure, yeah, just to reiterate some of the things that Raj said, because I think they're important. Number one, you have to understand what the requirements are that your company is facing. If you're a DoD company, most DoD contracts now have a specific DoD regulation incorporated into them, which then incorporates something called NIST 800-171 that lays out about 15 families of cybersecurity requirements. You have to make sure that you generally understand those, of course, but also that there are people in your company, both on the IT side and the IT security side, that absolutely understand those and they're implementing those. Even if your security team thinks they're being implemented, you need to make sure IT's actually implementing those controls, right? So understanding what you need to do in terms of the requirements and understanding what's actually being done at your company by both IT and by your cybersecurity folks is very, very important. It's also important not to just sort of push these requirements off on the IT group and expect them to do it, because they've got lots and lots of things to do. In fact, their mission may actually conflict with cybersecurity, right? They need to get the product out the door quickly. The users are, want everything to move quickly and efficiently, but cybersecurity sometimes causes that not to happen. So there's an incentive to sort of not do the cybersecurity sometimes. The management has to make sure it's being done, or there's going to be bad consequences. But then also having a plan to address all those things and address incidents if they do arise is very important. Yeah.
Thanks, Greg. I think that's a really important call out, that sometimes there's a tension between operational ability to move things forward and being really careful and thoughtful and putting everything you need to in place on cybersecurity. So thank you for highlighting that. Shobha, I know that you already went through several kind of nuts and bolts things that companies can do to mitigate their risks, but do you have anything else that you want to add?
Sure. I mean, just jumping off of Greg and Raj's comments, it's kind of the left-hand, right-hand point that I think is really important. So if you should have a security team that's separate from your IT and technology team, but all of them should be communicating and understanding what they're doing. And the people who are responsible, the stakeholders, the executives, the lawyers should know that this stuff is being implemented, particularly if you're, again, making representations to the government that you have a certain cybersecurity standard. You should actually have that, be meeting that standard. If it's a maturity model pursuant to the NIST, great. That's a great maturity model to follow. Have you actually met those expectations? And one of the ways I've seen that uncovered is actually through these tabletops, because it's building muscle memory for the executives, but it can also identify risks and gaps. So for example, if you go through a fact pattern and then you are going to have an IT person who's responsible to sit on the CERT team and an IS person, all of a sudden IT might say, well, we actually haven't implemented that yet, which has happened. I've literally had this happen at the tabletop. And the IS person said, but it was supposed to be on XYZ. And the question is, why aren't you guys communicating, to Raj's point? So I think this is something that helps getting the communication across the stakeholders through the practice, but also through identifying where the risks are, because all of a sudden you might be in the context of somebody certifying your cybersecurity to the federal government, and there's actually things in that certification that may not actually have been implemented. That's where all the gaps might be identified.
Something else I just remembered, this came up in a couple of my cases, so I thought it was worth mentioning. If you're acquiring a company that does government work, or you're acquiring a company to do government work, you want to make sure that those companies, have the right cyber security protocols in place. And if they don't, you got to make sure that you put them in place. Often there's you've spent a lot of money in this company. You want the company to start making money for you. So there's an incentive to get them to market, as quickly as possible, so to speak. And sometimes, they're not cyber compliant. And now you've got yourself a problem. So you want to make sure that occurs before they start working on their government contracts.
Yeah, thanks, Greg. That's a really important point. I want to go back to a topic that Shobha was just talking about, which is essentially stakeholders. And we know that boards of directors are key stakeholders that have a fiduciary duty to oversee and manage an organization's cybersecurity risks. So what, in your opinion, should board members be read in on? How detailed should that be in light of this environment?
Yeah, I think these days, larger companies, particularly those subject to some of the larger regulatory regimes, they have board committees that are cyber specific now and cybersecurity incident response specific. They may have board members sit on the CERT team. So you would have to account for that and thinking about your privilege relationship, because your outside counsel privilege relationship with the company may not extend to the board. So you would have to rethink how that would work. But it's really important for board members to be up to date. And one of the things the SEC's proposed rule requires is that the board members have more exposure to the cybersecurity standards at a company, but potentially have a board member with cybersecurity experience is something they want to disclose. Now, those rules have still not, that proposed rule has been a proposed rule for over a year now, and it's now, they reopened the comment period last month. I think it's open through the middle of May, so we'll see when those rules get implemented. But I think a lot of companies are in the position now to meet those requirements. And I think one of the things that Greg and Raj raised that I want to stress here as to the board's perspective is both the M&A risk. So cyber diligence is a big part of M&A deals, but I feel like with all diligence in a deal, everything moves so fast. I do some of this, so I see how fast it moves, and how quickly are you able to really assess the risk, particularly if there's a government contract, is really challenging. So at the very least, focusing on it quickly post-acquisition or post-merger if necessary. And then number two is these vendor and third-party relationships. So to Raj's point, no company is sort of in a vacuum, in a silo. They have relationships that are getting software services, product services, whatever. What is the cybersecurity expectation in that relationship? What data are you sharing with that vendor or supplier? What data do they have access to within your systems? Or is there a expectation? Is it a FedRAMP certified? And if so, if you're giving that data to them access to that same FedRAMP cloud, are they meeting the expectations with their systems? So there's a lot going on there. What are your identifications in that third-party contract if they get hit? And I think I've now seen a number of supply chain attacks where my clients are the third-party victims. So their vendor is the victim of a fairly significant ransomware attack, but their data is now at risk. So they have to give the notifications. They're the ones who are going to get sued. They may have regulatory inquiries, and it's because they relied on this third party to secure their data and maybe didn't think about the data retention policies, didn't think about what was encrypted in transit and at rest, didn't have an indemnity clause in their contracts. So these are all things that the executives and the stakeholders should be paying attention to, and frankly, the board needs to have visibility on, because there are some, you might be a company where like your primary service is actually provided by a third party. And are you thinking about that? How does that look? And I can imagine victims of what ultimately were the attacks on companies like Kronos and SolarWinds are rethinking a lot of those kinds of contracts as a result, because the impact was so significant to so many organizations, frankly, including the federal government.
Thanks, Shobha. Based on the fact that we're seeing this trend and in the SEC proposed rules, for example, of wanting more specific focus and expertise on boards of directors of cybersecurity, would you recommend to clients that they consider bringing on new board members who have that expertise, even if it isn't a requirement that governs them right now?
Yeah, I think it's becoming more clear to me from my experiences in briefing boards that there's a significant value to having somebody who's already literate and comfortable with the issue, so they're able to get engaged quickly on the risks from the front end, but also responding in the incident response as well. So yes.
Great. Thank you. Raj, I'll turn back to you. So earlier this month, the White House released a new national cybersecurity strategy documenting their approach to improving cybersecurity. What should companies and in-house counsel know about the strategy? And do you see any potential implications to the False Claims Act risk?
Yeah, absolutely. I mean, I recommend reading it, just a Google search away. But I think the one that's most relevant here is the third prong, which, I mean, just flat out says, shape market forces to drive security and resilience. And, I think we're seeing this from, across government, whether it's FTC has very, very aggressive enforcement of data privacy. They have an office dedicated to that, and, certainly go after companies that have incidents. So, things that are out there include, in the executive order, the phrase shifting liability for software products and services to promote secure development practices. This effort, I think, is flat out called out in there, ensuring the federal grant programs that promote investments in new infrastructure are secure and resilient. I think we're focused in this presentation on like a narrow sort of category of people who know they're dealing with the government and really ought to know that, the government may come after them if they don't live up to the cybersecurity guarantees they make. But I think the real takeaway here is that whether it's in the form of legislation, action by, administrative agencies, the government is taking cybersecurity very seriously. And so, like, anything you do in this space is going to pay dividends, or maybe pay dividends is too strong, prevent loss. Not just in the area of FCA compliance, but sort of across the regulatory landscape. So I think as a bare minimum, you need to know what your plan is, like how you would say you're securing data, how you would say you're providing services securely, how you would say you're protecting your operations from, ransomware, other cyber risks. And then the other thing I want to call out is just that you're living up to those things. I've heard, attorney-client privilege mentioned a couple times during this call. The reality is there is so much communication in this space, whether it's telling your board about your plan, whether it's, work that's being done inside the company to comply with it. A lot of companies rely on non-lawyer compliance folks to, shepherd through these certifications and things like this. There is going to be a mountain of stuff inside your company that is never going to be privileged that says what you think you ought to be doing. And if you aren't doing those things, that I think is a big risk, because, I still have like distant memories of, being a prosecutor. I don't want to prove that like your implementation of some encryption protocol is technically flawed, right? I want the CEO saying, this is a big deal, we have to fix it, and then never doing it, right? Like that's the type of stuff that makes a good case, that creates liability. So, and the reality is, I just don't think you're going to be able to privilege all of those conversations around what you should be doing. So make sure that you're living up to what you've said you do, or at least you can point to, here's the work in progress. We've identified, 20 areas of improvement. We might 5 high priority, and these are the teams that are working on them in this quarter. And then in the next quarter, we've got teams working on priorities 5 through 10. I think that's the type of stuff that it will be very beneficial to be able to point to if you're ever, held under scrutiny. The context of a False Claims Act came, or, some other government regulatory agency coming after you. So that's my take on this, is just that, there's no escaping this. States are also entering into this space. I won't totally derail this conversation, but there's going to be increasing amounts of regulation over cybersecurity. So start preparing.
No, that's a great segue. Thank you, because I wanted to take this beyond the initiative, which is what you've done. And Shobha, I was hoping to go back to you. So obviously, this initiative doesn't apply to those companies that aren't government contractors or federal government grant recipients, but there are many federal and state regulatory regimes that will govern cyber and security across industries. So generally, of course, this could be its own session, but can you give us an overview of what in-house counsel should be aware of with regard to these other regulatory frameworks?
Sure, I think the answer is all of them, right? So it's everybody cares about this. And so if they don't have a regulatory rule, cyber-specific regulatory rule yet, it's coming, to Raja's point. But CISA, which is a part of the Department of Homeland Security, governs the critical infrastructure security. So any entity that is a covered entity pursuant to CISA rules would be obligated under those rules to meet certain cybersecurity requirements and also make disclosures within a certain amount of time. So it's a 72-hour disclosure requirement if you're a covered entity, which is, like, I would say 60 to 80% of the companies out there. They haven't defined what covered entities are under the new rule, but if you look at the list, it's almost everybody, right? A financial institution, education institution, not just energy, not just water. So be conscious of the robust rules that are expected of you in the critical infrastructure space, and those keep changing. But of course, I mentioned if you're a public company, you have SEC requirements. If you have consumers, you have FTC expectations. If you have healthcare data, you might have HIPAA requirements. There's a 50-state regime, as Raj mentioned, and every one of those states, the AGs have certain enforcement authorities. They may have state regulators that may have enforcement authorities. If you're a financial institution, you would have a different set of regulators as opposed to a hospital, as opposed to an education provider. All of them have expectations based on their own individual regulators, and your disclosure requirements are going to be along those lines as well. So you should be prepared in whatever organization you are, whatever industry you're in. Who do I have to tell if something happens is like its own question, and it's usually a very large spreadsheet. So it's something to be thinking about, because those rules change and how quickly you have to tell people. So if you have customers and their data is stolen, exfiltrated during a cyber attack, and they're in 47 states, but it's stolen and or accessed, meaning they looked at it, you might have to tell people at a different time frame. So the people, I think in like Vermont, you have to tell within 14 days, but you might have a reasonable amount of time in California. What is reasonable, right? So the timelines are really important too. And this goes to my strategic communications planning point. You want to be saying the same thing, the same words as to what happened, so you're not inconsistent, because you're creating litigation risk. And to Raj's point, you can't privilege everything. Oftentimes in responding to an incident, some of that can be privileged, but your gap analysis from 8 months earlier, where you said we should probably do these things and then you didn't do them, and then that's the reason for this vulnerability exploited, that's going to create problems for you, right? Because that is probably discoverable. So that's why thinking about this prophylactically and in anticipation of, rather than reactively, is so critical. And again, it goes back to the point of educating, literacy. The executives need to understand, the stakeholders need to be bought in, I think is really important.
Thank you. And just another plug for having outside counsel at the ready on these types of issues. I'll say I think it's difficult as in-house counsel to stay abreast of all of the different states' regulations on disclosure obligations and timing, for example. So you need to have someone at the ready to help you if this were to happen. So we have a few minutes left, and I wanted to leave some time for questions. And I see we've got one here in the chat. Is lack of disclosure and omission treated as bad as direct fabrication regarding violations and penalties? Greg, I'm going to start with you on that.
So, I'm sorry again, it's lack of, could you repeat the question?
Yes, of course. Is lack of disclosure and omission treated as badly as direct fabrication regarding violations and penalties?
It could be, depending on the context. Of course, in this arena, there is an affirmative duty to, in most circumstances, to report incidents or breaches to your cybersecurity system. So if you don't do that and you're submitting claims for money, that could be a problem. That could implicate the False Claims Act just as much as if you certified that you were doing these things and you weren't doing them. Sort of a direct, sort of in broader terms, under the False Claims Act, a direct false claim or an express false claim or an express false certification is not necessary for liability. In fact, many of our cases are premised on what's called implied certification, the implied certification theory, where if you're claiming money from the government, but at the same time you're knowingly you're knowingly breaching a contract materially, or you're knowingly not following a material regulation, that's a False Claims Act violation. So I guess there are situations where you're not doing something quote unquote directly where you can get tangled up in the False Claims Act.
Great, thank you. Shobha, Raj, do either of you have anything to add on that question? I think Greg covered it pretty well, but go ahead, Shobha.
As a practical matter, I think the answer is yes, right? So to Greg's point, if omission is as much as an affirmative lie, if you're failing to tell them something you're supposed to tell them, right? I think that's the point here. So if you have an incident, you're required to disclose it under your government contract, and you don't do that, that is issue one. That potentially could be its own sort of implied certification. But then the other problem is, what if you then certify, yeah, we're totally secure, and all the things in your certification include, have you had any incidents in the last 6 months or whatever the time frame is? And you, again, don't say anything. That's an omission, but now you've falsely certified that affirmatively. So you've got two problems there, and potentially two arguments toward the claim. So I think it just kind of goes back to the original point of, you want to be prepared and don't lie. Failure to disclose can be termed a lie under FCA for the implied certification point, but it also is going to create regulatory regime issues because you may have an obligation to disclose, and failure to do so creates enforcement liability.
Great, thank you so much. I don't see any other questions in the chat, so I'll give another minute to see if anyone wants to send one our way. And while I'm doing that, I will repeat the CLE code as promised. It is 21194. Okay. Well, we are about at time. Thank you all so much to our panelists first for joining us and giving this wonderful, helpful presentation today, and to everyone who joined. Please remember to download the materials from our handout section, including the CLE forms. And thank you very much. Have a great day.
Take care.
Thank you, everyone. Thanks for listening.